Vybz Kartel Court Appeal to 024.
The Interception of Communications Act is a breach of the Charter, and the reason, quite simply, is the legislature has decided, effectively, the limits of what are justifiable interferences with the right to privacy by imposing a procedure that needs to be gone through before there can be interferences with that right to privacy. And if an individual such as Corporal Brown goes beyond those restrictions, in our submission it becomes clear that it can't be justified, essentially, because as I say, the legislature has set the limits. There's a sort of analogy we draw in our written case between the point my Lord Reid made in the Osborne case about how human rights standards are often in very general terms, and it's for domestic law effectively to fill in the gaps. And that's what we say the Interception of Communications Act does in this case. It is what fills in the gaps in a very general statement about the importance of the right to privacy. And that's why it's so important, compliance with it. And that's why, in our submission, it is comply with the relevant legislation. The Interception of Communications Act is a breach of the Charter, and the reason, quite simply, is the legislature has decided, effectively, the limits of what are justifiable interferences with the right to privacy by imposing a procedure that needs to be gone through before there can be interferences with that right to privacy. And if an individual such as Corporal Brown goes beyond those restrictions, in our submission it becomes clear that it can't be justified, essentially, because as I say, the legislature has set the limits. There's a sort of analogy we draw in our written case between the point my Lord Reid made in the Osborne case about how human rights standards are often in very general terms, and it's for domestic law effectively to fill in the gaps. And that's what we say the Interception of Communications Act does in this case. It is what fills in the gaps in a very general statement about the importance of the right to privacy. And that's why it's so important, compliance with it. And that's why, in our submission, it is the deceased, his girlfriend, or Mr. Chow. All the indications are indicated that it goes beyond that, and that's why these safeguards matter in our submission. Two other provisions worth just noting. Firstly, partly so I can avoid going back to them. Firstly, Section 16 is the right to a fair trial by an independent and impartial court. Included within that, in the criminal context, at subsection 6G, is the right not to be tried in your absence. That is obviously relevant when we come to the jury issues. It does have some implications, though, for the first issue, the admissibility, because in our submission, and we've made this clear in our written statement of case, Jamaica is, as far as we can see, the only Caribbean country that has used independence essentially as a way to enhance human rights. And one sees the fact it was intended to enhance human rights in the Joint Select Committee report that led to the Constitution. If you go to 8213, this is the final report. There is a lengthy history, and we've set it out in our written statement of case. I'm not going to take you to it, and we've included the materials about it. There's a lengthy history of debate. It was a particularly long debate process. But the final report of the Parliamentary Joint Select Committee, it helps in two ways. Firstly, it makes it clear at 8213 that the Constitution was influenced by other written constitutions, and that's partly why we submit we're entitled, for example, to refer to the Irish constitution because it is a written constitution with similar features. Clearly, part of the aim of this process was to reflect developments in other states. More importantly, though, in one sense, one of the recommendations of the committee, which was adopted Yes, I mean, obviously that's an important...
Can anyone seek redress for a breach of anybody's constitutional rights?
Well, in our submission, anyone can enforce those rights because of the first point I made, which is about the need...
That's what you're seeking to do in these proceedings.
Sorry?
And that's what you're seeking to do in these proceedings.
Well, that's what... Yes, because that... Well, it goes back to the Muhammad...
It's not your constitutional rights that were breached on any view. It's not the rights of Mr. Jones and Mr. St John.
That's... Well, there clearly were issues in relation to one of the defendants, but as constitutional rights, because there was data in relation to one of them.
That's
but
Mr. Campbell.
Yes, Mr. Campbell. But the more important point in any event is that what this case law, what Muhammad it recognises is that, and this is made even perhaps more expressly clear by the Irish Supreme Court, is that if the courts simply ignore breaches of constitutional rights, then there is then the problem is that there's no incentive essentially on the state to comply with them, or there's very little incentive on the state to comply with them.
Well, Muhammad was dealing with a breach of the defendant's constitutional rights.
The jury.
Sorry, no, he told, yes, you're right, he told the jury, but the problem is that in one sense is part of a package. I mean, because what the Court of Appeals say before that, and they expressly rely on this, what he was told before, and certainly the judge doesn't stop the forewoman doing this, is that she was also going to effectively taught this, what was apparently said by one of the defendants to the juror's son, because she became distressed at that point in time.
Maybe the judge didn't go as far as he should have done in the questioning, but my question relates to where it should have taken place, whether it was in open court or whether it was in the judge's chamber.
Well, there's a strong, I would argue that current practice generally is that there is a strong presumption in favour of it being in front of the defendant so that they can contribute. If there is a particular concern, I accept that you can question in the absence of the defendant, but you have to just... Here, part of the criticism is, in one sense, it just seems to have been assumed it wasn't going to take place. It's not clear what the evidential basis for that or what the reasoning was.
Well, there was a particular problem here which was thought to have emanated from one of the defendants, because he'd seen the juror in the prison.
Well, he'd see, what had happened. Yes, but I mean that on its face is not something that's. There isn't a very clear record of how certain key acts were taken, and I'm particularly thinking then, in relation to that, of the role the forewoman then takes in terms of sort of reassuring the jury. And going back to this incident, probably more important than the point I just was making, which was that this was in the absence, is that. If you look at, going back to paragraph 36 of the Court of Appeals judgment, one of the things that happened was that the forewoman indicated that she would soothe everyone's mind, I think is the language used. That is, in our submission, quite clearly not the same as giving a helpful direction, partly because, it goes back to the point I was just making, there's simply no record of what she does. One doesn't know what she says. One of the reasons why a direction is so important in our submission is because it means there is no doubt as to what the jury are being told.
Mr. Buchanan.
If it pleases the court, lords and ladies, I just wish to make a couple points, but to start with questions, the clarifications to questions. The first one being raised by Lord Lloyd Jones. And this would have been in relation to in relation to the chamber hearing. Now, in the Jamaican context, the right of the accused to be present at all stages of the proceedings, the concept of the chamber hearing, respectfully, would be that the courtroom would become the chamber.
Yes.
So the gallery would be cleared, and certainly the attorneys, the representatives, and then you would have the accused there.
The bench book says that.
That's correct. But my lord, in that situation, because it was a situation within the transcript which reflects that it was actually a conversation between one of the appellants and the son of the jury. She didn't actually see or confronted the appellant. And so she was concerned, so she only heard information, and the inquiry didn't go as far as to find out the truth of that inquiry. And so it led to a discharge. What follows from that is the opportunity would have been lost for the appellants, if questioned, or to say, well, this is not true, and then the judge would have made an informed decision. What follows from that also is that the foreman, she was a part of the questioning. She was then asked if she was allowed to, if she could continue. She says, I'm only worried about the safety of the lady, the juror number 11. And she leaves knowing the information, and it's fresh in her mind and remains in her mind. We have no way of knowing but to speculate how much conversations outside of that would have gone to the other jurors. Then, moving back to the next inquiry number 3, it is the same forewoman, and more conversations about her role, and so the taint or the poison would have gone back as far as November in a 65-day trial, and before juror number 11 left. So a proper inquiry could have found out, especially in a space where we do not know at what point or if any, when it is exactly the responses, or if the other jurors could have said that that wasn't the case at the time, if a proper inquiry and asking each and every juror, not even suggesting that it be done on the oath, but if it was asked, what their responses would have been for the judge to make an informed decision. And I say this in the context that, in light of the fact that our Constitution, it places even a duty on the judge to, as the custos morum of the Constitution, to protect the rights of the appellants, that it was incumbent on him to ensure that he makes the inquiry so he protects the fair trial right. So that would be in response to your question as it connects. So what flows from that then is when we get to the late retirement, we have a juror who is the fruit of the poisonous tree, or the introduction of the poison, no knowledge of how far the poison is. I'm not inviting the court to speculate, but that's all we are left to do, respectfully. And what happens in that situation is we don't know if the pressure arises because there was a situation where these jurors were able to say, I would participate in a bribe, allegedly, or not. And so the verdict that comes could never be a true verdict in light of that. So that's the submission as it connects from incident 2 to incident 3. Now, in relation to the proviso, and I think you had knocked some of the wind out of me, say, Lord Reed, because I would have borrowed your words in the judgment to say that you can't proviso unfairness, you can't proviso unjust. It's just not possible. It would have been an absurdity in the law. Now, in relation to Lady Simler, you asked a question about the balancing of rights, the balancing exercise. I would submit to you that the Jamaican Constitution, in particular the Charter, it came at a time post the Phipps decision. So there was a lot said about King and certainly Phipps, the Phipps judgment. But at that time it was presumption of constitutionality, and certainly the onus was on the appellant, to prove the privacy right violation. Post the judgment in Phipps, our legislators, which our parliament certainly has that ability to represent the people, and they would have thought that as a matter of public interest, the very right, the charter rights, in particular the communication rights, which is for all, the least among us has that right, was to be protected in such a way that where there is a breach of that right, it's a distinct difference. What difference is that? Lady Simno would have asked, is that the judge now has a duty to carry out the Oakes test or the demonstrably justifiable test, because somebody says, and in response to Lord Reed, but the appellants are not here to complain of that right. But they did at first instance to their counsels collectively. And at that basic complaint about the right follows that the judge is to call upon the prosecutor to say that it is demonstrably justified because there is no issue before this court that there was a breach. The effect of the breach or the balancing exercise can only begin after the prosecutor has met the burden of demonstrably justifiable.
Can I ask Mr. Buchanan, while you're addressing us on the Charter, as I understand it, the Charter is formally, is part of a constitution. It was made part of a constitution by a constitutional amendment in 2011.
That is
right?
Correct.
Was it preceded by some sort of review or report?
My learned friend actually, Mr. Salty Casey, actually made mention of the review and the report.
But
right. What is significant?
Check my notes. Right.
What is significant that comes from it is that, and we take pride in this. And I'm quoting. I'm paraphrasing our Chief Justice, and it's found. Thank you. It's found in the written case at 12 and 13. Yes.
Right. Thank you.
Yes. But what as I was saying earlier, we take pride to say that this amendment, which is separate from any other Caribbean jurisdiction, was for us. It was made by us, and it was a testimony of our evidence of independence.
Yes.
Where we decided what rights would be protected, and especially the dynamics of the Jamaican society. Yes. Is the importance of protecting the least among us.
And was it intended that it be developed, I suppose, was it meant to be what you might call an autochthonous Bill of Rights, if we can call it that would be developed by the Jamaican judiciary in light of circumstances in Jamaica? Or was it intended to be influenced by comparative human rights jurisprudence looking at other charters of rights and constitutional guarantees in other countries?
I'm happy that you asked that question, because we did look, and I'm saying we because I take pride in being Jamaican, but we did look at other jurisdictions such as South Africa, and if you even the Canadian and the United States. But what you'll see, a clear indication, and again my friend is indicating that it's in the written case at 20 and 21. Yeah. But what's significant is that what is clear is that there is, similar to in the Canadian jurisdiction, that the test, which is the demonstrably justifiable test, is mandatory once there is a breach. And before us now is that there was a breach. The learned judge, and I will say this respectfully, this came at a time when the charter was very young. And so the contemplation to give effect to it, as judges do in interpreting the intent of the legislature.
Yes, and I see paragraph 13 draws our attention to what the Chief Justice Sykes has said, that it's autochthonous, which means it's indigenous, homegrown, originating with us, rather than imposed from outside. Yeah.
And what is key, which I will get to, and I agree with you, and I adopt the words of our Chief Justice, is the fact that after looking at constitutions all over the world, what we decided is what is important to us. So what we have is a section 13.2b, and I know there are many persons, I quote it so much that it becomes an annoyance to many, but 13.2, the protection given to every citizen under 13.2b, it is the last flicker or shimmer of light to what it is to be a human.
Yep.
And it separates the state clearly from the human being. And it says, listen, all state actors have a duty not to abridge, abrogate, or breach the rights. And when you do that, you must show that it is demonstrably justifiable. So in an answer, yes, thank you. So in an answer to that, ladies and gentlemen, that balancing exercise as to the evidence when it was asked about, especially in relation to what was on JS2, doesn't even begin to come up until after the judge would have carried out that exercise of the demonstrably justifiable test, and he did not do it.
Yeah.
So we have nothing on the record as to any submissions from the state, from the Crown, to say, here, notwithstanding, it is justifiable. There were less restrictive measures, or here's why there is a breach. So we don't have that before us, and that is the one flaw in the judge's acceptance. And evidence of that is he was concerned. He made words to my senior, Mr. Taylor, who is in the room, that if he was not daunted by the change in the charter, and the significance of it, the response at that level was nothing much changes even after the concession. But we do recognize the importance of it, but to submit to the court that the test wasn't done, and so there's no balancing exercise to which could have happened. And because this is our apex court, the apex court could not respectfully substitute what the judge at first instance ought to have done. And in those circumstances, the answer to question A, where evidence was collated, collected, and secured. So secured would have been the request from the police officer. The collection and collating would have been what flows from JS2, the cell site, the text messages, the call positioning, whatever flows from JS2. But all of that would have been no moment. And a key thing before I depart, because I don't want to take up too much time, or
you don't have a great deal of time left.
I was being cheeky, Lord Reed, but I didn't know you would figure me out. But the key thing in relation to that aspect is to understand that as we make heavy weight of JS2, what's incumbent on the judge was that in a demonstrably justifiable test, I would submit respectfully that in the absence of JS1, which was the controlled copy that the police officers did not have access to, and where the much counsel from the lower level, which Tom Tavares, KFC, would have said, listen, this is a man from Ireland would have come to Jamaica, not given any effect to the right, and he gives testimony. This is Simon.
Nobbled by the corrupt member of a jury. That's a matter for them, and he can go along with that.
My Lords, he has to be satisfied that the other 10 won't be nobbled, or it's very unlikely they'll be nobbled. I'd accept that. But if his thinking is, and I submit it was likely to have been this, I've got one bad juror here, I've got good reason to suppose the other 10 will behave properly. That means there will be, the jury will be quorate at 11. In my submission, he is entitled, he is not bound to say, I've got to stop the trial now. He has a power to allow the trial to go ahead. That is, and my Lords, I accept that is the kernel of my submission. It has to be one which he exercises not entirely unreasonably in all the circumstances of the case. That is why I'm making the submissions I have been.
If it were the case that the same rules applied in Jamaica as apply in England and Wales, that is, you could have had a jury of 10, what would you then say?
My Lord, I think I'd be bound to accept that the judge would have said, let's go down to 10. He probably would, in those circumstances, have said, balancing.
So the problem that you're faced is a system that doesn't allow a jury of 10.
That's exactly the problem. The whole problem.
An unfair trial, it might be put against you, is allowed because the rules don't allow a jury to go around to 10. Is that right?
No. I'm not saying that. I'm far from saying that. As long as the trial is fair, overall, I haven't come to my point about the fairness of the trial, but as long as the judge is satisfied that a fair verdict can be returned, even though one juror appears to be bent on assisting the defence, the judge can say that the lesser of two evils is that the trial goes ahead, the administration of justice is served by the trial going ahead, and there is no common law rule that requires me to stop the trial.
The corrupt juror might be critical, his vote might be critical to whether there was a majority or not.
It might be. But in those circumstances, that is a risk that the prosecution takes.
Well, that's the point. That's the point I'm jibbing at, really.
Yes.
The idea that responsibility for the administration of justice in the public interest is the responsibility of the prosecutor and can effectively be waived, if you like, by the prosecutor, rather than being the responsibility of the court.
Yes, I do accept that, but my Lord, it is still the responsibility of the court. If the court is satisfied...
But we see the problem. If you're presiding in a criminal trial where a majority verdict can be returned, and you know that one of the members of the jury, or you have good reason to suspect that one of the members of the jury may be corrupt, for all you know, the way he votes in the jury room could be critical to the verdict that's returned, and could result in a wrongful acquittal, for example.
My Lord, again, I come back to my point. The judge is entitled to weigh up all the different evils. I mean, the real problem is that the judge was caught between two evil solutions.
Yes, I've got the greatest sympathy for the judge. And I mean, in this country, we would think twice about rerunning a 67-day trial. But in a country like Jamaica, the expense involved in this, apart from anything else, is enormous.
But, my Lord, my submission is this: as long as the prosecution is acting responsibly, and as long as the judge is acting responsibly and reasonably, rationally in making these decisions, and as long as they are satisfied that overall there can be, not necessarily that there will be, but there can be a fair verdict, if there can be, then in my submission the lesser of two evils is to go ahead and get that fair verdict, rather than simply say, trial off, no verdict, which in real life may well mean no trial whatsoever. And that is why I say one must look. It's not just a matter of sympathy for the judge, it's what is the responsible, forgive my putting it this way, the responsible response to this very, very difficult situation. Which is the lesser of two evils? And my submission is the lesser is to go ahead in the hope that there can be a fair verdict. You may well land up with an unfair acquittal. That is one risk you take. But it is better to take the chance of getting a fair verdict than to abandon that altogether.
That fair verdict would be reached in circumstances where the allegedly corrupt juror would not only have a vote, but he'd have the opportunity to influence the other members of the jury.
Well, he might still seek to influence the other members of the jury, but he wouldn't. Sorry?
In deliberation.
In deliberation. He can still say what he likes in deliberation. He can still draw attention to a good point, let us say. That can still happen. He's not prevented from doing so. He may well be able to persuade one of the other jurors, not by offering money.
Well, by offering money.
No.
But he may.
No, he may be able to persuade one of the other jurors in deliberation. Look, forget about my bribe. These people are innocent because of point X. He's still entitled to do that.
Well, he's entitled to do that, but he's not entitled to persuade them by offering them bribes.
Certainly
And that is an ongoing risk.
That is, my lady, I accept that is an ongoing risk.
Yeah.
That must be right, is a risk. He will try again.
Yeah.
I mean, you might think it's a bit unlikely if the matter's been reported to the judge, actually, but there's a possible risk. Let us say there's a possible risk. My lady, even in those circumstances, if that is a risk which the prosecution is prepared to take in order to achieve a verdict, that is the lesser of two evils, and if both the judge and the prosecution think that is a proper way of proceeding, they can. That is my fundamental point. And one of the problems with jury trials is one is trying to create a system of perfection, in one sense. Of course this is not perfect. No one would begin to say it's perfect. But is it, in fact, the pragmatic way forward, which did, in the event, secure a fair verdict? That is
but the defendant's counsel didn't accede to this way of proceeding. That they continued to raise well, on the face of it, it looks as if they were objecting.
They did. There's no doubt about that. But they were objecting for different. They weren't objecting on the core point, but they were objecting because of the way it's put. I think by one of them is the overcompensation point. I'm concerned about it, and that's a fair point.
Yeah.
I'm not saying it's a bad point, but in my submission, it's not a conclusive point. The judge is entitled to say, well, I'm still prepared to put this matter to the jury because of the various points I'm going to come to later, because the strength of the case, I've been assured that I will give another direction. I have already given directions about not being persuaded by extraneous matters. The judge in my submission, and this is in a sense the heart of the case, was he bound to stop it? My answer is no, he was not bound to stop it, for the reasons I've given you. And I do submit, I take my Lord's point about the Court of Appeal's judgment, but I do submit this is important to bear in mind what the Court of Appeal had to say about this matter. They have familiarity with how juries work, how the system works, and it's their primary responsibility to ensure the criminal system works properly. You are operating as a second review court. This is a point that's been made again and again. And I do submit great respect should be given to the Court of Appeal's assessment on this point.
Well, it will be.
But so, my Lord, you have my point on that. So I say there was no error of law in what the judge did. That's what it boils down to. He acted within his discretion. It was not an unreasonable decision to make, given the extremely difficult circumstances in which he found himself, and the possibility that there could still be a fair verdict. That's the point. My Lord, can I just turn to
that would be a relevant matter going to their guilt or innocence. But of course their job is to decide it in accordance with the evidence. Isn't the real problem here that it would be a temptation hard to resist to decide or to be influenced in the decision of the case by something other than the evidence presented to the court?
Well, to be clear, I'm not saying it wasn't conscious bias. What I'm dealing with, what I'm dealing with is, in one sense, my learned friend's submission, which is to say you can trust the jury to comply with a direction that they should there is a problem with how detailed the direction was, but let's assume that the direction was sufficiently detailed. You can trust the jury to comply with a direction that they should disregard this factor. I mean, there's no reason in practice why it couldn't have said, because the jury were all meant to be aware of the bribe. I'm aware some of you have been approached about a bribe. You should. Now, The prosecution submission is you can trust the jury to comply with that. Whether that's realistic as a matter of human nature may be open to question. But assuming that's right, you still have the problem that even if a juror says to themselves, I understand that this looks pretty bad, that there was a bribe offered to us, but I understand what the judge has said. I need to put that out of my mind. It is very difficult, and this is why I focused on the unconscious bias aspect. It's very difficult as a matter of human nature to actually stop yourself unconsciously being influenced by that, because that's the way unconscious bias works. And that's why. It's because I'm in one sense focusing on a particular difficulty that in our submission simply can't be addressed by a direction. But I accept that in reality, conscious bias is a very real problem here. Yes. Can I am in terms of the just a couple of final features. Firstly, the procedure adopted. All we would invite the court to look at is, because my learned friend relies on it very heavily, Braithwaite 7358. The importance, in particular the citation at para 52 of an earlier case called Ball, the importance of matters being properly recorded in open court, which is the problem with the use of the forewoman, for example. That is important because it allows essentially
Day
the
2
answer is for the legislature to introduce legislation such as England. If the system becomes undermined, essentially, there are solutions. The solution isn't to allow a trial to continue in circumstances where there is a lack of independence. That was the context, though, of my learned friend's submissions, which fundamentally were that the judge's discretion was exercised correctly in not discharging the jury.
I take it there's no evidence about jury tampering in Jamaica that's before us?
No.
Thank you.
Certainly not that I'm aware of. My learned friend's next submission, based on what I've just said, was that the judge exercised his discretion correctly. It was an exercise of his discretion. Firstly, given what I've already said about the Porter-McGill test, the Lawal test, in our submission, that's the wrong question. The real question here is, was the constitutional right to an independent trial by an independent court breached? That's important because the suggestion was essentially all that the judge had was a mere allegation. Firstly, we of course know that there was in fact a conviction, but secondly, in any event, the issue is real risk. My learned friend said the judge was entitled to rely on the forewoman's role, and in particular the fact that she said that none of the other jurors had taken a bribe and that they would follow their oath. Part of the problem with that, the primary problem with that, of course, is where you have unconscious bias, by definition, it is a problem that the individual may find difficult to discount, whatever their sort of professed approach will be to decision making. That's why, if you think about Putnam in my submission, Lord Justice Bingham made it clear there comes a point where you have to discharge the jury if, for example, the poison has been allowed to spread for too long. The second point is, of course, that was all information obtained through the forewoman, and that is a problem because of the lack of any public record of what the jurors themselves said, and I'll potentially come back to that. The third point my learned friend made was that the Court of Appeal upheld the conviction. Unsurprisingly, we would say that the approach of the Court of Appeal, particularly paragraph 238, and I won't take you to it, everyone's familiar with it, obviously demonstrated a flawed approach. Some further points that my learned friend made to justify essentially the outcome in this case. The first was that the bribe was offered by someone who was seeking to favour the defendant. In submissions, unlike in writing, it appeared to be accepted that there's no evidence that any of the defendants was to blame for the bribe. That's important because it means none of them have taken actions which could in any sense be said to be effectively a waiver of their rights. But more importantly, Putnam is clear authority, and it's 7579, that there is a risk of prejudice against, and that's obvious. People do overcompensate. And then a friend said, you can tell that the jury is independent because it acquitted Mr. Williams. Already made the point, effectively, that we would submit that the jury simply couldn't lawfully deliver a verdict. But in any event, bias doesn't necessarily mean that someone will always deliver a verdict that is the verdict sought by the party they favour. Bias means essentially you're more likely to favour one party than the other. The fact that the evidence, put it this way, you can have a case where a biased individual acts against their biases because the evidence is so overwhelming. That doesn't mean they weren't biased. It doesn't mean that there isn't a higher threshold to overcome if the bias is against you. Bias simply means you favour one party over the other. That's, in our submission, fundamental. And that's why the acquittal of Mr. Williams, in circumstances where the evidence against Mr. Williams appears to have been particularly weak, dependent on Mr. Chow alone, doesn't necessarily mean that there wasn't that the jury didn't favour the prosecution in light of what had happened, unconsciously favour the prosecution. Now, my learned friend, in terms of jury independence and the relevance of Mr. Williams' acquittal, initially cited Gregory. Gregory, in fact, was the one where it was the case where the European Court found no violation of Article 6 in light of directions. Gregory, though, was followed by Sander, which my learned friend, I think, this morning accepted was the case where one person had been acquitted. The approach of the majority of the European Court was to find, and you see this at, I think it's 7956, paragraph 30, was to find a violation of Article 6 because a racist juror can't be expected to change their views in response to a direction. Now that is, we would submit, consistent with Putnam recognising that there comes a point essentially at which prejudicial views become so embedded that you can't change your mind. My learned friend pointed to the dissenting judgment in Sander, but that's a dissenting judgment. The majority approach in our submission is the correct one, as I say, reflecting Putnam, and that demonstrates the real problem in relation to the second aspect of my learned friend's case, which is the impact on the other jurors, which is the judge simply didn't have the information to know whether or not this was a poison that could realistically be discounted on the basis of a direction. My learned friend also said you can discount unconscious bias because of the strength of the evidence. The jurors will essentially have said that they didn't need to consider the corruption because the case was so strong.